Assalamu alaikum students. Today I am going to study the topic wrongful restraint and wrongful confinement. When we open the Bail Act of the PPC 1860, we see that this topic comes under the sections of chapter 16A, and it's a very wider chapter, and it also includes sub-chapters like kidnapping and abduction, criminal force, assault, battery, of rape, unnatural lust, and it's a very explained topic and explained chapter. But as we see the past papers and the annual paper and the supplementary paper of LLB part 3, we come to know that only point of view of the examiner to ask this question is only surrounds the wrongful restraint and wrongful confinement, and it's very important question and repeated question, so I think that it's much better to read this topic only in this video. Coming towards the relevant section of this topic, we see that 339 to 348 sections we read in this chapter, and these are the total 10 sections almost. Firstly, I want to know you that what is the main difference between wrongful restraint and wrongful confinement, because it's a very important topic and the students find it much difficult to differentiate between the both terms, because examiner ask usually them what's the difference between the two terms, because it apparently the both terms are similar. To wrongful restraint and to wrongfully confine appears to be the same terms, but there is a slight difference between the two terms. If we talk about the wrongful restraint, it shows that you have an open choice to change your path, to change your remedy, to have a separate path from the particular point. And when we talk about the confinement, it shows that you cannot cross your limit. You are confined to a particular area, you are limited to a particular point. I will show you some illustrations. I will describe you this lecture with some examples before coming our bare reading. Let's suppose that a person A obstructs, stop or prohibit person B to pass from a particular way, the way which is owned by the person B. It means that B is the owner of a particular passage, particular way, particular filter plant, or a way which goes to a shopping mall, or a way which goes to a school, or a way which goes to a university, or a way which goes to his office, or whatever it is about. But he is the owner of the test plant, and he has the lawful authority to pass from that way, because he is the owner, and he can use this right anytime, at any time, at any where, at anywhere, at any place, at any time, without any terminologies, without any limit, without any condition. But Mr. A obstructs the Mr. B from passing from that way. It means that he is hurdling, he is obstructing, he is causing a hindrance in the way of the Mr. B. In lawfully enjoyment of his right, he is hindering. It shows that although Mr. B has a lot of ways to go towards the shopping mall, he has a lot of ways to go towards the school, he has a lot of way to run his business, to pass from the filter plant, but he is obstructed by the Mr. A to specifically he cannot cross, he cannot pass, he cannot use this particular way. He is restraining the Mr. B from passing that particular way. It means that he has restrained the person A to enjoy his lawful right. Okay. And when we come towards the confinement, it shows that Mr. A has confined, Mr. A has limited Mr. B to move or to stay or to stop within a boundary, within a room. It may be a room, it may be a building, it may be a certain province, it may be a certain district, it may be a certain city, it may be a certain country even. It means that if Mr. A asks Mr. B, you cannot come from this room, you are limited to stay within this room, you cannot cross this boundary, you cannot cross this window, you cannot come away, you cannot come forward from this room. He has confined the Mr. B within the room, he has confined within the district. Confinement is of a lot of types. It may be he is confined to a room, he is confined to an office, he is confined to a district, he is confined to a religion, whatever it, but it may be strict to, you may be restricted to place, certain place, it must be a certain place. Okay, and that's in this case we say that it's a wrongful confinement. Okay, coming towards the bare reading, it shows that section 339 says wrongful restraint. When we read this section barefully, we say that whoever, it means that everybody of any age, of any gender, of either adult, either minor, whoever, okay, whoever voluntarily means by his will, by his free consent means consent irrespective of undue influence, consent irrespective of misrepresentation, consent irrespective of fraud, consent irrespective of any kind of coercion, okay, whoever voluntarily by his all senses, I am making a lot of easy words for you guys. Bare reading says thus, whoever voluntarily obstructs any person so as to prevent that person in proceeding from any direction in which he has a lawful right to proceed, we say that he has committed the wrongful restraint. And when I will make it easy for you, this reading, it shows that whoever of any gender, man, of any adult, either minor or of female, obstructs, stop any person, either it's a natural person, either it's a legal person, from moving a particular direction, from moving a particular passage, from moving a particular way in which the other person has lawful authority, in which he has a lawful right to pass. In this case we say that he has wrongfully restrained that person, okay. When we comes toward the bare reading of wrongful confinement, we come to know that firstly I will read the bare, then I will show you with illustrations. I will make it easy this section for you with the help of illustration, with the help of examples, so guys you may know each other, because this topic is very important and it's much important for you guys to make differentiate between this wrongful restraint and wrongful confinement. Even I was unaware before preparing this lecture that what's the slight harm between these two terms. I was considering these two terms totally similar, but I come to know there is a large of difference between these two terms. Okay, coming towards the bare reading of wrongful confinement, it says that whoever wrongfully restrains any person in such a manner that such person is prevented beyond certain circumstantial limits is said to confine the person. It means that it puts a certain limits which the other person cannot cross. It puts a certain restrictions, okay. In the case of wrongful restraint, there is no restriction. He can use alternative way, but he cannot pass from that way which is prohibited or which is restrained or which is obstructed by Mr. A. But in the case of wrongful confinement, you have no alternative remedy, you have no alternative passage, you are totally bound, you are totally area bound, you are totally confined, you are totally limited to a particular point, okay, to a particular place. Coming towards section 341, it says about the punishment of wrongful restraint. When we come to the bare reading, it simply says that whoever commits a wrongful restraint against any person shall be liable to 1 month imprisonment. It may be either description. I have discussed this with you, either description, in my earlier videos, that whenever the words came to you, either description of imprisonment, you may consider it either rigorous with hard labor or with simple, okay. It may punishment of wrongful restraint says that it may be liable to 1 month imprisonment or with fine, which may extend to 1500 or with both. In case of punishment of wrongful confinement, we come to know that the offender will be liable to 1 year imprisonment of either description or may be liable to fine of 3000 rupees or with both, okay. Okay, section 343 says that whoever commits wrongful confinement against the person, it may be a legal person, it may be a natural person, it may be an adult, it may be a minor, it may be a male, it may be a female, it may be a she-male, or it may be a animal, but I'm not damn sure about it, okay, for 3 or more days. It's a time limit. It's a time limit, okay. For a time period is mentioned, time period is specified for 3 or more days. It may be liable to, the offender may be liable to 2 year imprisonment or fine or with both, and the amount of fine will be fixed by the discretion of the court. Section 344 says that wrongful confinement for 10 or more days. Here the time limit is increased. Here he has confined a person from 10 days, from starting 10 days to up to extend to more days, up to 1,000 days, up to 3 months, up to 4 months, up to 1 year time. A maximum time limit is not specified, but the limited time is 10 days. He shall be liable to 3 years of imprisonment plus fine. Plus fine means that also liable to fine. It's not compensatory, it's not compulsory. These two things are compulsory, it's not optional, because in the earlier section we have said it's optional, either he will be punished with imprisonment or he will be liable to fine. But in this case he will be punished with 3-year imprisonment and also liable to fine. He shall have to compensate, he shall have to fulfill the two descriptions. Okay, 345 says that wrongful confinement of person against whose liberation writ has been issued. Okay, liberation means liberty, freedom, a person to move freely, a person right of freedom, a person right of movement. Writ, you can say that whenever your fundamental right which is mentioned, which is specified, which is contained in the Constitution of 1973 section article 8 to article 28, all these talks about our fundamental right, in which included right of life, right of privacy, right to have family, right to earn property, right to have your own partner, and etc. And whenever your fundamental right is infringed, you make a sue in the high courts or in the Supreme Court, and it is known as writ. Okay, and the Supreme Court and the High Court have the jurisdiction to trial these offences whenever your fundamental right is infringed. And keep in mind this section, keep in mind the two articles. Under the article 199 you sue in the High Court, and under the article 184 subclause 3 you can make a writ petition in the Supreme Court. Okay. He says that wrongful confinement of person whose liberation writ has been issued. If a person wrongfully confines that person against which a liberation writ has been issued, against which a court has been declared to free that person, to release that person, if a person confine that person, he shall be liable to 2-year imprisonment and also liable to fine. The amount of fine shall be determined by the discretion of the court. Okay. Section 346 talks about the wrongful confinement of persons secretly. It means that whoever confines a person, either minor, adult, she-male, male, female, irrespective of all these. Secretly means who is not having any demand from the interested person of that confined person. He does not demand any kind of property, whether movable or immovable, from the person interested. He is not interested in any kind of it. He just want to confine that person. He just want to make tense that person. He just want to irritate that person. Whoever does this, he shall be liable to 2 years imprisonment and also liable to fine. Section 347 talks about the wrongful restraint for extorting property or to illegal act. Okay, it shows that whoever confine a person to obtain certain property from the person confined or from the person interested in it, means that his parents or his relatives, his sister, brother, father, mother, whatever he has having. Extort, to obtain, to get property, to wrongful gain property. Property may be either movable or immovable, which can be moved, which cannot be moved, or his intention is to perform a specific illegal act from the person confined. He will order him to commit such illegal act, otherwise he will kill him, otherwise he will continue kidnapping him. If a person do this, he shall be liable to 3 years imprisonment and also liable to fine. Section 348 talks about the wrongful confinement for extortion of confession. Confession means you can say that evidence to a false evidence, or to make a willful representation that I have done this, to make acceptance of anything which he has not done, to make false acceptance that I have done this. For example, Mr. A compels Mr. B, or Mr. A wrongfully confines Mr. B that I will not release you until and unless you accept in public that I have committed a murder. And Mr. B, by harassing by Mr. B, by being worried, he declares in front of the public that I have committed the murder. In this, as we say that he has wrongfully confined that person for the extortion of confession, that he must confess that I have been murdered. Okay, or restoration of property, or a person wrongfully confines a person for restoration of property, to give back to the property, either movable or immovable, or he's either a person interested in it, and we say that he will be liable to 3 years imprisonment and also liable to fine. Here is our today topic. It's very easy, and the bare reading is also much easy, and the concept is slightly different, and I hope so you have already discussed, and you have come to know all my lecture. And if you have any query left, if you have any question left, do write in comment. I will try to answer all your comments. Okay, thank you so much.